The term reasonable accommodation is pretty much open-ended under the ADA. An accommodation only becomes unreasonable if it would pose an undue hardship for the employer. Most courts will consider these factors to determine whether a particular leave request is reasonable as an accommodation. The amount and length of leave, the frequency of leave usage, the employee's flexibility in terms of the timing of leave usage, the predictability of the employee's leave usage, and the impact on the employer's ability to get its work done in a timely manner. But there is one thing on which all federal courts agree: indefinite leave, or leave of an unknown duration, is not a reasonable accommodation, regardless of the employee's circumstances. This is important. An employee's request for leave that is open-ended, indefinite, with no discernible end date does not have to be granted. It is not a reasonable request as defined by the ADA. Yet, a case-by-case evaluation based on multiple factors like those I mentioned makes it really difficult on employers to know what is the right thing to do. Depending on the particular circumstances, leave of up to 6 months and occasionally longer has been recognized as reasonable by some courts. All is not lost, however. In the last few years, there has been some welcome clarity from a number of federal appellate courts which have decided that while a brief period of leave to deal with a medical condition may be reasonable in some circumstances, multiple months of leave is inherently unreasonable. Reasonable accommodations are limited to those that permit the employee to perform the essential functions of their job in the immediate or near future. An employee who requires multiple months of leave, the reasoning goes, is not a qualified individual with a disability because they are still not able to perform the essential functions of their job until sometime later, and thus are not entitled to coverage under the ADA. Even with this changing landscape, employers must exercise care when considering whether an employee's leave request for extended medical leave is a reasonable accommodation. Remember, the employee does not have to give an exact date, but must be able to provide an approximate date and a reasonable explanation as to why they are able to perform the core functions of their job then. So what, as an employer, should you be thinking about doing in light of the ongoing uncertainty about requests for leave under the ADA? Here are a few suggestions. 1, update your policies. Make it explicitly clear that you as an employer intend to engage fully in the interactive process, but will not deem indefinite or open-ended leave requests as reasonable. 2, do not be hesitant to obtain relevant information from the employee to determine the feasibility of providing leave as a reasonable accommodation without causing you an undue hardship. 3, consider when the employee can do a modified work schedule or whether telework might be an option. And 4, continue to follow me for future updates on this subject and other employment-related matters.